Well, welcome back to the channel. If you've been here before, Veterans Day KVA employees, everybody watching, they always greatly appreciated when you come back. Please remember to share if you like what you see here so that others may join as well. And if you're new to the channel, hey, welcome to the channel where we talk about VA disability as we build a platform that makes the process easier for veterans and VA alike. And again, don't forget to subscribe and share as well if you like what you see here and bring others aboard here. Hey, as always, I'm Attorney Matthew Lang, VA accredited attorney, here to talk about VA disability with you. I did a video recently where I was talking about the rating decision, if I recall that correctly, and there's a spot where I mentioned we should talk some more about a topic, and if I remembered, because I get so busy back here, sometimes I forget what videos I've made, So I want to make sure I don't forget about that, and let's go ahead and get a little bit of a conversation started for that topic. And the topic I'm talking about is weighing and assigning probative value to, well, medical and lay evidence, or any evidence actually of record when it comes to the VA disability claim. So there is a requirement in the law for the VA to evaluate all evidence that's submitted in support of your claims, veterans. They've got to figure out what a probative value is of each medical and legal piece of evidence and determine how much it all weighs. So they're going to go through a series of processes to do such. Some that has really been laid out by statute, some that's been laid out in further guidance with court decisions as well. So I'm going to give you a brief summary of really what that is here. And then we're going to walk into the VA's manual a bit and go through that. Now, this part of the manual, I think, really describes a better detail as to what should be in that rating narrative that we spoke about before, especially in that reasons section. But I will caution VA, I know there's another section that hints to this piece, but it really feels like it, in my opinion, leaves you with the other idea and why your decisions may not have the information that's required by statute. But we're going to leave that piece out today for the sake of time. We'll come back to that at some other point. So, what is the probative value of evidence? Well, we're going to go through a series of tests. We need to know competency, we need to know credibility, and then we need to lead into that probative value. So, what evidence is going to get weighed first to determine competency. And what this refers to is the legal sufficiency of evidence to be considered. So medical evidence must come from, say, a qualified healthcare provider, for example. We're not going to just take medical evidence from Joe off the street here who has no medical degree. So is that medical evidence competent? Is it done by an actual provider? This is an example for you there. Now, what about this lay evidence, though? We retain a lot of times buddy statements, which is a lay evidence. Well, we can say that in lay evidence can be competent in cases where it pertains to observable symptoms, for instance. I mean, say, for example, veterans, your spouse can be competent to say, I observe this symptom from the veteran this many times a day, and this is how I see it affect their life. That is competent. It's competent evidence. They're competent enough to tell you what's going on right there in front of them. So then we have credibility, and that's the reliability of evidence. So the VA's got to consider factors such as consistency with the record, plausibility, maybe even potential bias as well. The courts have outlined factors for assessing credibility, which include, again, that facial plausibility, the consistency with the evidence, and the veteran's motive in providing the statement. So really what we're looking for here in credibility, veterans and VA, is, here's the best example I got for you. If there is a lay evidence that says, veteran, you suffered an injury during service, and this buddy over here witnessed that injury, then the question is was it plausible for that injury to really occur? For example, if I say in my buddy statement to help you out here, veteran, if I'm that buddy and I put in my statement that I witnessed you be injured at Camp Lejeune on such and such a date, and the records don't show you were there at Camp Lejeune on such and such a date or near that date, or maybe never were there, that could be a credibility issue towards the lay statement Now, there are exceptions in these hypotheticals, but for the basics, understand that line that we're talking about. Is it consistent with the record, essentially? Does all the evidence really line up? Now, we're going to talk about other things because we may find that evidence may not talk about that, or the medical evidence may not talk about the injury, and whether that is enough to say that is a credibility issue or not. And we're going to find that's not the case here. So just keep in mind, on the surface, credibility essentially doesn't line up with the rest of the evidence in the file. So once you got the competency figured out, you got the credibility figured out, we've got probative value that we've got to talk about. What does probative value refer to? Well, that's the weight given to the evidence in establishing a fact. So the VA's got to assign a greater probative value, say, to a medical opinion based on a thorough rationale and review of veterans, say, your history. So here's, for example, something I run into quite often. Let's say, veterans, you filed your claim. VA says, I got a duty to assist in obtaining a VA medical examination and opinion. VA gets that medical examination and opinion back, and let's say that opinion really doesn't have any probative value to it because it fails to discuss your history, veterans, of your condition and, say, your service, and it doesn't give a thorough rationale as to why the examiner is providing the opinion for which they are. But in turn, say, veterans, you then decide, okay, well, VA isn't getting it right. I want another opinion. I'm going to go out in the private world outside of the VA, and I want another doctor or another medical professional that is qualified to do as such to review my evidence or your evidence there, veterans, and put together their opinion. Now, a lot of times what I see is their opinion will counter what the VA's opinion counters. But in order to determine which one's got more probative value and more weight, we've got to look at, again, does that new one actually talk about a more thorough rationale and a review of your evidence, or really your history, veterans? In a lot of cases, we find it does. So then that could be one example of, well, probative value weighs more on the private opinion, not the VA opinion. And as such, the private opinion meets the criteria for a nexus when it comes to service connection. Again, just some basic examples. There's definitely a lot of other rules that could come in play, other things that could happen with these examples, but just understand the basics is what I want to get to you today in this video. Now, keeping in mind, with that example I gave there, understand when medical evidence like that conflicts and it exists in the record for you veterans, the VA must explain its reasoning for assigning a greater weight to one or another. VA, I'm pointing this out because what I see from you, and I'm again not saying this happens every time, but the hundreds of cases that I review back here representing veterans, all of them demonstrate no explanation or valid reasoning for assigning a greater weight to, say, a VA medical examiner or physician over a private physician. I see a lot of times the discussion is, yeah, we see it, so bad, so sad, so bad, whatever, we're not going to pay attention to it. That's pretty much what it comes down to. And then your decision VA goes into, well, this is what our VA medical provider provided for us, and this is what their opinion was. And then when you look at it, you go, yeah, but that doesn't carry any weight because it's inadequate underneath what the courts and the laws say. So just keep in mind, VA, this is something I'd watch out for because I think you're making more work for yourself. Because once you kick this claim out, people like myself, now stand up for the veteran, in representation, and we're going to appeal it, and we're going to argue that point every time. And what's going to happen is every time you ignore it, we got to keep appealing. So really, you're just constantly bringing that case back to somebody else over and over and over again, and you're really never clearing out the case in the way you're supposed to. So just just food for thought there for you. We also have other things when we go through weighing evidence and adding probative value, and that's really called a benefit of the doubt rule that comes into play from the law as well. So if the VA at any time finds the evidence is for and against a claim and it's approximate balance, the veteran ultimately prevails underneath the benefit of the doubt. This is kind of also known as an equipoise issue as well. So veterans, we'll talk more about it here as we go through the VA's manual a little bit here. If I remember right, I highlighted that in there to make sure I mention it. But the idea here is that the evidence may be so closely related in the value of it all and in the weight, where one side says no to your service connection and the other side says yes to your service connection, that VA is then ultimately required to give the benefit of the doubt and weigh everything in the favor and grant the benefit. That's just another part of the application of weighing evidence and all the probative value and so forth. So anyhow, there's a quick summary, kind of what that is. But I want to also go through in this video just a little bit of VA's manual here really quick. Okay, really quick, right? We're going to probably do another 10 or 15 minutes of this. Maybe, I don't know how far. But I want to give a better idea to veterans, especially what's in here, and to help VA know what's in their manual too, because I find from my experience when I was training and stuff that the VA would not always refer back to their manual. They kind of go off of what somebody would say. They go ask a question, hey, how do we do this? And somebody go, oh, you do it this way. And then the reference isn't being utilized. Now, as I mentioned here, I want to also go through this piece because I feel this is a better piece than the other piece of the manual where I feel it kind of contradicts or creates an interpretation of contradicting what's really required in that narrative you write, VA. So let's get together here and let's look at this. So I'm ultimately going to be in, for those who want to look it up, M21-1, Part 5, Subpart 2, Chapter 1, Section A. Now this is titled Principles of Reviewing and Weighing Evidence. So it's really down our ballpark right here. So we have a part in here that actually says evaluating evidence. Now this is what the manual tells us. Refers to a series of analytical steps that must be performed by a VA decision maker in making findings of fact for the purpose of drawing conclusions of law on each aspect or criterion of the legal standard for entitlement to the benefit and the applicable procedural matters. So, evidence has got to be evaluated. Got to know what it is. Before you can really write your decision there, VA. Now I want to go back just a touch there. It looks like I missed a page, and instead of re-recording the whole video for you, I want to give you I'll leave the blooper in here for you. Sometimes it's good to know I'm still human, right? We also note in another part of the manual here, just right before that reading there, that the decision maker will evaluate evidence after verifying that the claim has been properly developed and procedurally prepared for a decision, but before a written decision on the issue is drafted. Now, I want to bring this one out, and I didn't want to forget this piece when it comes to all this, because here we really are seeing that there's a process in place of really pre-evaluating the evidence before really evaluating the evidence in the rating decision. So when I was drafting decisions, this is the way it looked for me. I had to do pretty much an analysis and a preview and take notes of all the records that were relevant to the claim at issue. Now, this was my pre-weighing of evidence at this point. But when I did this, I was also verifying again that all this claim development was done properly. I'm responsible as a decision maker at this point for everybody before me. This is a legal decision. My name's going on it. I better have it right. So if it's not done right, it needs to go back to the people below me and say, all right, it needs to be done. And that's the way it worked in the system. So we're usually talking RVSR to VSR or DRO down to, maybe VSR, that low as well. But what these notes were really helping do is verify again that all issues were recognized, that all the development was done for all the issues that Veterans U had claimed, that nothing was missed. Maybe we would find one actually where there's an issue missed, and then we got to go back and look at that evidence too, so we can weigh all that out. The duty to notify was discharged. The duty to assist was completed or appropriately discharged. Now I'm highlighting this one again, VA, for you because I see in 99% of the decisions that come back here where I help veterans with their appeals that I get the impression no one is checking that duty to assist being completed. Claims are just being done. The copy and pasting of the VA exams that are inadequate, which means duty to assist is not being completed, is just being thrown into a decision, and the decision is being walked out the door as fast as it can. So understand, your manual is even telling you you must verify all this stuff before you even get to writing that decision. So keep that in mind. And this is something I had to do before as well. I'd have to sit there and make sure, okay, did we get the exams we needed? Did we send out the proper notification letters? Did we send out the letters that said, hey, I see that you, maybe Veterans, you provided indication you got private treatment outside of the VA system. Did we provide you with the proper VA forms so we could get the release of that information? I mean, all this stuff comes into play. This is what's supposed to be thought about first when we're going through the evidence. So that gives you an idea there of what that section is and why I wanted to highlight it. So let's move back into where we were. So now that first section I really was talking about, it gives a whole lengthy table here, and for just the sake of time in the video, I'm not going to go through the whole thing, but you can really see it stepping the VA. It steps you right through ultimately the process of assigning that value to the evidence and kind of discussing it and resolving questions to the weight and so forth there. It takes up about a whole page. It actually takes up a whole page by itself. Good, and actually more than a page. It goes to the next page as well. So fairly big section. It definitely looks important to me. Now it does note that the rating activity is responsible for reviewing the evidence in this case. Now keep in mind that the rating activity is not the only one. I mean, when we have certain types of claims, we have decision review officers who are responsible for this as well. So the VA's manual goes on to say when making decisions or taking action on claims that require a rating decision, again, we're talking supplemental claims, new claims, increased claims, high-level review. The rating activity must apply the provisions of all pertinent laws, regulations, schedules for rating disability, policy statements, procedures, administrative decisions, secretary's decisions, Court of Appeals for Veterans Claims, and all other legal precedents governing VA. VA, I'm highlighting this one for you because I want to help you out with this one. I had found in my career that when it came to training you, and some people may not find this very likable of a comment, and it's kind of what it is at this point. I'm really just trying to be helpful. But when training you, it was found that when you weren't really trained on like the new, say, court cases or how to apply those to the decisions, you weren't really given all the policy letters. Maybe you weren't, I mean, sure, at some point you might be. I remember being trained on court cases years after they happened, and we've already been making 2 years, 3 years, 4 years worth of mistakes. So what I want to point out here to you, VA, is even at times where you may hear from colleagues, which I had before, which really was frustrating and discouraging. Not everybody. There's people who understood it, that they need to review this stuff. But you may hear from some that, well, we don't apply all that other stuff like the court cases here and all that, and that's not our responsibility. Well, your manual does show it is, and it honestly is underneath the law. So when you write your decisions, you've got to take all this stuff into, and I know it's a lot of information, because I'm doing the same thing back here, taking all that information into consideration. But you've got to stay up with this information, and you've got to be able to take it in consideration. So I would recommend VA just to help you out, some of that self-study. You may want to follow the Court of Appeals for Veterans Claims. See what the cases are that come out. Read them periodically for the ones that look relevant to the jobs you do. And just kind of follow up with the manual changes and make sure you're sticking with the changes in laws and so forth. Because all this is prudent when you're weighing evidence and assigning value. All these have really good information and requirements for you to follow. The reference really goes into now some standard of proof issues here. The note that's in this manual here is the application of standard of proof is qualitative and not quantitative. I want to point that out because here's something else I see that I think we can do better on, and again, help you out, VA. There are multiple claims I put in appeals for veterans where I see notoriously, which has always been almost the number one issue since even I worked for the VA in the beginning from 2008 and on, that the VA exams or opinions, specifically the opinions, would lack an adequate rationale or opinion. So what happens is, well, we get an appeal. You get us a new medical opinion, and we find the same problem after a decision is made. It's inadequate underneath all those rules and laws and regulations that we talked about you had to know. So we do it again. We might go back and we might argue again. Well, look, that one's inadequate too. You shouldn't have made that decision. And we do this maybe 3 or 4 times, or how many times before I get tired of this and we go find our own expert who can actually review and understand the rules and regulations and give us an appropriate opinion. Now, if that opinion is negative, I'm obviously not going to continue the appeal and give that to you, VA, because that doesn't work for our claim. But many times what happens is I find that when I take them, I know that they should be a positive opinion. And when those examiners say, or those physicians say, yes, this is positive, they review all the records that I give them and everything, they say yes to it, then we put that in the record. And then what I find, VA, is you will say, nope, denied, because essentially quantitative evidence, 3 or 4 bad VA exams apparently outweigh one good, detailed exam or opinion in this case. So keep that in mind, VA. Just because there's more evidence doesn't make it more qualitative. So I wanted to highlight in there as well. So when you're doing the weighing, when the weighing and probative value and so forth, all this evidence is being done, just understand that you're looking for qualitative, not quantitative. All right. What else do we have here? We do talk about reasonable doubt here in the VA's manual as well. They do say it is defined and consistently applied policy of the VA to administer the law under a broad interpretation, consistent, however, with the facts shown in every case, when after careful consideration for all procurable and assembled data, a reasonable doubt arises regarding service origin, the degree of disability, or any other point. Such doubt will be resolved in favor of the claimant. So I point this out again too, VA, because really in order to do this, you really have to give us a good analysis in your narrative when you essentially weigh and look through all this evidence and you come to this conclusion whether it gives the benefit of the doubt or it's resolved or it's got reasonable doubt, whatever the level is that is required at that point for the standard. Because without doing so, I think the problem here is that what we face on this side is that we struggle to read your mind in most cases, so we don't really know how you came to that conclusion, and that's really what we're trying to do here is make the decision easier to understand, like it's supposed to be underneath the law here. And then it does cite some good court cases. You'll see me actually use a few times there, VA, when it comes to that standard there. Keep in mind that your manual, the VA manual here also says that with a few exceptions, because there's always exceptions to the rules and laws like we've talked about, right? But with few exceptions, all evidence submitted is admitted into the record. It's all admitted, unless it's usually like a duplicate or it's for a higher level review where we're not allowed to submit that evidence, for example. So once it's submitted on record, well, what do we got to do? Well, VA, your manual goes through and talks about, well, what we're talking about here today. We got to get the credibility. Some factors to consider making a fact finding on credibility include facially plausible. Is it possible for the veteran to have a back condition or arthritis in the back even today when they're served in a combat zone wearing a bunch of heavy equipment and never had it documented in their STRs because of the situation they were in? Sure it is. Happens all the time, right? Consistency with other evidence submitted. Of course, we talked about that a little bit. There's some other little factors in there that we can talk about as well. But essentially, that's what we're doing now. We're going through the credibility here. We got to talk about the competent piece of evidence where your manual goes here, VA. Refers generally to evidence offered from a qualified source. Determination of evidentiary competency involves analysis of whether a person offering evidence is qualified to establish matter. Did you hear that? Analysis. I can't be in your mind, VA, so help us out here, would you? Give us that analysis. Tell us why you think the evidence is competent or not competent. We definitely talked about that competent medical evidence piece, lay evidence piece. There's definitely some more of that here in the manual as well. Now, keep in mind, evidence has probative value according to the VA's manual here if it makes a matter material to the determination more or less likely and has sufficient weight either by itself or in combination with other evidence to persuade the decision maker about a fact. So again, I won't know that unless it's discussed. I can guess. Can't read minds, but I can guess. All right. So now, keep in mind though, when we're weighing evidence and we're assigning all this value and seeing that everything is admissible at this point, with a couple of exceptions. Now, veterans, you got to understand, not every piece of evidence is going to be positive in your case. Not every piece of evidence is going to be negative in your case. So either way, both positive and negative evidence must have probative value according to the VA's manual here and according to all the rules and regulations in general. So again, we're going to be looking for that analysis and that detail on what that probative value is for, again, persuasive, unpersuasive, or positive and negative evidence. You'll hear me call it persuasive or unpersuasive in my legal arguments, as that's kind of the way the law deems it a little bit more there. Now, when also weighing the evidence, though, the VA, underneath different series of court cases, has also been told more than once, unfortunately, do not use the absence of evidence as negative evidence in cases where the claimant has simply failed to prove an element of the claim by applicable standard. So this is one thing I want to point out too, VA, is I'll see a lot of times you use a conclusionary text. I know why, and I think it's that other reference that really has you doing it that we're not going to talk about today. But the idea is when you put in that can text that the service treatment records do not show how's it go again? A diagnosis, a treatment, or complaint of an injury or disease or illness in service. That you got to explain that. Why? Why does that weigh yay or nay towards the veteran? It's still part of the weighing process. You got to, again, if that's negative evidence, why is it negative evidence? And we see a lot more of that in your manual here that really discusses how to do that and look for that a little bit more. If it doesn't weigh one way or another, well, what evidence creates that weight? Where do we go with this? How does it happen? So the idea here is you can't use the absence as negative evidence in cases, and what you're going to find further on in the manual here and some of the other guidelines is without a really good explanation. So by just giving me that statement, VA, I'm going to tell you I'm appealing you every time because I don't have an explanation to why that matters. I find many times what happens is you fail to look at the other evidence, a record, or it would appear so, because again, I can't read the mind, that is favorable, that actually fulfills the element, even though those STRs are not documenting any of that. Anyhow, enough of that. There are a few court cases in here that the VA manual does give a little description of probably good to know. It does talk about some of the Trafter v. Shinseki is one on here. I suppose I'll make mention to it. Held that the VA is precluded from considering the absence of evidence as substantive negative evidence to decide the VA has complied with the duty to assist provision. I'm going to put that in there too, because it's kind of another way where we see when you go to weigh evidence and look at it, is that you can't say VA that you've complied with your duty to assist provision just because, for example, the STRs don't document anything. You're not precluded from your duty to assist just because there may be an absence of evidence, or maybe there's negative evidence in there at some point. Well, we got to look at everything. We got to look at the full picture that's placed in front of you at the same time. So your manual is really talking about it. The court cases talk about it. The laws talk about it. It's all there. So let me just shorten this up here. We went a little ways. I had a few more things in here, but I think we got the point for this video. I like to think. But always go back if you, veterans, this is all out there on the internet for you to read, public. Check it out. See what's being told of the VA. Kind of get some of those references out of there. All those laws, that's public. I'm not going to hide anything from you. VA, it's public. You also have it in your internal systems as well to read as well. So I think it's a good read for everybody. Check it out. Get an idea of what you're going to do when it comes to weighing and assigning probative value. Look at that competency issue, that credibility issue. Try to figure out that probative value. Look at how the manual reference is really telling you have to discuss all this evidence, and you can't just leave conclusionary text. Now, again, we're going to leave that other one aside that I think really hints to the idea of conclusionary text only, but we're not going to get there today. But that's really the idea. Veterans, so again, that's how it should probably look in a nutshell. When it comes to reviewing all your evidence, the VA should be reviewing it all. They should be verifying stuff, making sure their duties and legal obligations are met, which, as I see from my practice, again, the bad and the ugly, that's not the case when claims come to me. And then they should be really giving an analysis and discussing, again, that positive, negative, that unpersuasive, persuasive evidence, why it leans one way or another, how that's determined, and it can't be just conclusionary sentences in that determination. So there's a lot that goes really into, or should be going into, weighing evidence and assigning probative value, is my point of this video. So there you go. I wanted to get that out there and give you a really quick rundown of what weighing evidence is, what probative value is, and how it really should be done. So if at any time, veterans, you don't feel that VA has really weighed your evidence or looked at everything correctly, feel free, veteranlang.com. Go to my website there, click a button, schedule a time on my calendar. You can also get my phone number there from that website. You can always give a call and set up some time with my team here, who will put you on my calendar. If you're in the Arizona area, feel free to walk into our new office location here on Grand Ave, right next to the VA clinic here on Surprise. If I'm available, I'll sit down with you right away. Bring in the evidence, bring in your decisions. Let's talk. Let's see if I can represent you in any way and see what kind of arguments we can make. With that, everybody, thank you again for your willingness to create a system that is easier for both VA and veteran alike to get veterans the benefits that they're entitled to. And have a great day. I'll see you in next week's video.